Hello friends, welcome you all to the Citizen Justice Forum video channel. Our mission is to empower Indian citizens by sharing knowledge about the Constitution of India and their fundamental rights which inherent by Constitution of India. Our mission will be successful if you like, subscribe and share our videos with your contacts and friends, and it will be greatly appreciated. Then today's topic is compliance by managing committee and their members of the housing cooperative society. A very powerful topic. आदाब, नमस्कार, सत श्री अकाल दोस्तों, आप सभी का स्वागत है सिटीजन जस्टिस फोरम के इस वीडियो चैनल पर। हमारा मिशन है भारतीय नागरिकों को जागरूक करना और उनके अधिकारों के बारे में जानकारी देना जो उनको हमारे भारतीय संविधान ने दिए है। अगर आप हमारे चैनल पर पहली बार आए हो तो कृपया उसे सब्सक्राइब कीजिए, बेल आइकन को क्लिक करके सिलेक्ट ऑल कीजिए ताकि हम जब भी नए वीडियोस अपलोड करते हैं या ऑनलाइन आते हैं तो आपको उसकी जानकारी प्राप्त होगी। और हमें बहुत खुशी होगी अगर आप ये हमारा वीडियो आपके दोस्तों और संपर्कों, आपके जितने भी कॉन्टैक्ट्स है मोबाइल के ऊपर उसके साथ में आप साझा करेंगे तो। और आज का जो विषय है वो हर महाराष्ट्र में या पूरे देश के अंदर जो कोऑपरेटिव सोसाइटी में रहते हैं, ज्यादा करके मुंबई, पुणे, नासिक, वहां पे कोऑपरेटिव सोसाइटीज बनी है और हर मेंबर चाहे वो कमिटी मेंबर हो या नॉर्मल मेंबर हो, उसको क्या कंप्लायंस है, उसकी जवाबदारी क्या है, मैनेजिंग कमेटी की जवाबदारी क्या है। और बहुत से टाइम पे आप देखेंगे, अभी आप डीप लेके जाएंगे आपको कि जो बायलॉज है वो भी एक दूसरे के खिलाफ है, कॉन्ट्रडिक्टरी है। एक बायलॉज एक चीज बोलता है, दूसरा बायलॉज दूसरा बोलता है। और बहुत से टाइम पे हमने देखे 79A में भी एक हाई कोर्ट का जजमेंट है जो थोड़ा सा कंट्रोवर्शियल है। और 79A का जो 3 का पार्ट है वो बताता है कि अगर 79A प्रोसेस फॉलो नहीं किया है तो वो 6 साल के लिए डिस्क्वालीफाई हो सकता है। तो ये सब बारीकी हम जानेंगे। हमारे साथ में तो हाउसिंग सोसाइटी के जो हम अथॉरिटी जो बोलते हैं, चार्टर्ड अकाउंटेंट अमित इसरानी, वो हमारे को एक स्टेप करके डीप में लेके जाएंगे और जहां पे मुझे लगेगा वहां पे हम पॉज लेके और डीप में जाएंगे। ओवर टू यू।
Namaskar. Welcome to the session of understanding your duties, responsibilities, rights, obligations, and functions. दोनों का है, members का भी है, फ्लैट ओनर्स का भी है, ऑक्यूपेंट का भी है और मैनेजिंग कमेटी मेंबर्स का भी है। उसके बाद में अभी जो अमेंडमेंट आया है 2019 में, उसमें रजिस्ट्रार का भी कुछ ड्यूटीज और फंक्शंस बैठता है। और मैं आपको एक एक करके लेके जाऊंगा। और पहले हम बात करेंगे मेंबर्स का राइट्स क्या है, मेंबर्स का ड्यूटीज क्या है और मेंबर को क्या क्या कंप्लाई करना है। क्योंकि सोसाइटी में पहले आप मेंबर बनते हो, उसके बाद आप मैनेजिंग कमेटी के मेंबर बनते हो। तो अगर आप अपना बेसिक फंडामेंटल्स कंप्लाई नहीं करेंगे तो फिर आगे चल के कॉन्फ्लिक्ट आता है और प्रॉब्लम होता है। फर्स्ट रिक्वायरमेंट इज एवरी मेंबर मस्ट अटेंड जनरल बॉडी। जनरल बॉडी मीटिंग है वो मीटिंग ऑफ मेंबर्स है। द ड्यूटी ऑफ द रेजिडेंट्स, द मेंबर्स और जॉइंट मेंबर्स और एसोसिएट मेंबर्स और प्रोविजनल मेंबर्स हु इज आल्सो अ मेंबर अटेंड करना बहुत ही जरूरी है। गिव देयर कंट्रीब्यूशन, गिव देयर सपोर्ट, गिव देयर आइडियाज एंड कम आउट विद सॉल्यूशन टू द प्रॉब्लम। जब हम मैनेजिंग कमेटी मीटिंग में जाते हैं या हम अपने जनरल बॉडी में जाते हैं, क्योंकि मेंबर को मैनेजिंग कमेटी मीटिंग में भी राइट है जाने का, उसका सब्जेक्ट मैटर वहां डिस्कस हो रहा है, तो ही कैन गो फॉर दैट आइटम व्हिच इज हिज मैटर, participate in that meeting, give suggestions with the problems, then leave the managing committee to take over the other matters. तो एक बहुत इंपॉर्टेंट चीज है कि कोई भी मेंबर जब ही लिखता है कमेटी को कि मेरे को ये प्रॉब्लम है, उसके साथ में उसको उसका प्रोबेबल सोल्यूशन और पॉसिबल प्रैक्टिकल सोल्यूशन भी देना चाहिए। ये प्रॉब्लम है और मेरे हिसाब से अगर हम ऐसा करेंगे तो ये प्रॉब्लम सॉल्व हो जाएगा। अगर खाली हम कंप्लेंट लिखते हैं और मैनेजिंग कमेटी इन इट्स ओन विजडम कुछ आंसर निकालती है, देन देयर इज अ क्लैश, योर आंसर इज नॉट इक्वल टू व्हाट आई एम एक्सपेक्टिंग, और फिर वहां लिटिगेशन में चले जाते हैं। तो फर्स्ट फंडामेंटल है कि हमको लिटिगेशन अवॉइड करना है। Moment a society enters into litigation, we are asking for trouble. Division हो जाता है, boxes बन जाते हैं, you and me हो जाता है, managing committee you है और member me है. तो you and me का फिर चलता रहता है musical game, and it leads into a lot of trouble for all the other members. Disturbs the decorum of the house. अभी इसमें जनरल बॉडी मीटिंग में अगर आप जाएंगे और सब लोग आएंगे तो you can have a collective decision, and if you have any dissent or objection you can lay it before, discuss it. और दूसरा important चीज है कि जनरल बॉडी को जो पावर है, many people don't realize the power that is there. General body is ultimate. It is the supreme body of the society, and all decisions there are binding on all the members. दूसरा है कि there are issues like penalties or there are issues like disagreements. जब आपको penalty आता है तो penalty आपके bill में penalty डाल देता है. That is not permitted. I have already spoken on this at my previous talk. So I will repeat it again. Managing committee does not have the power to put penalty in the bill. उसका एक प्रोसेस है. अभी पेनल्टी का दो सेक्शन है. एक सेक्शन नॉर्मल पेनल्टी ऑफ द बायलॉ बोलता है if there is a breach of the bylaw. दूसरा बोलता है if there is a breach of another bylaw where it is a question of encroachment or occupancy of common area. और एक साइड बोलता है मैक्सिमम कैनॉट बी 5000 और दूसरे साइड में वो कुछ रिट्रोस्पेक्ट की बात करते हैं कि रिट्रोस्पेक्टिवली यू कैन चार्ज 169 में आता है 165 और 160. उसमें क्लैश आता है और लिटिगेशन आता है बिकॉज इट इज कॉमन नॉलेज दैट पेनल्टी कैनॉट बी पनिशमेंट कैनॉट बी गिवन prior to the date on which the law was made. So retrospective effect, I think Sulaiman bhai probably can throw some more light on the retrospect part of it.
Yeah.
So उसमें आपका क्या opinion है? Because I feel कि I can't be penalized for something which happened even before I came. I may have bought a flat with a particular encroachment already done, and I get a debit note for 20 years or 30 years. How do we reconcile that fact?
Yeah. So in that matter, there are going to be a lot of controversies and lot of cases going to be filed. I'll just read out the section which you are referring to. There are two sections. The one bylaws is 165 and one bylaws is 169. So I will read out the most controversial bylaws which is being misused by some of the managing committee members against they have some revenge or some grudge. So
you read the 160.
First I read the 165.
Okay, the original bylaw.
The original bylaw 165. Penalties for breach of bylaws. Right? So if there is a breach of bylaws, then there is a penalty.
Can I interrupt you?
Yeah, please.
The wording is breach of bylaw. It doesn't say of a resolution passed at general body. So in the general body they may pass a resolution कि अगर आप स्पिट करोगे तो आपको 1000 रुपया फाइन है. हमें नहीं है. So can that be enforced or not? It's a subject we will go as we go along.
Yeah.
But you have to understand the difference between breach of bylaws and breach of a decision taken by
the general body meeting. So the 165A clearly says the meeting of the general body of the society may prescribe penalties for different breaches of the bylaws of the society. The secretary of the society, under instructions from the committee, shall bring to the notice of the member concerned the breach and the breaches of the bylaws committee by him. If the member persists in continuing the breach or breaches, the committee shall give the notice to the member to show cause as to why the penalty should not be inflicted on him for breaches of the bylaws. The general body meeting, after considering the say of the member and after giving hearing, they levy penalty at the rate fixed by the meeting of the general body. Then it has to be fixed in the meeting of the AGM, or if it is a very say demanding, then you can call a special general body meeting also, but it has to be a general body meeting of the society. Maximum penalty of rupees 5,000 in one calendar year in that particular year. So I cannot levy more than 5,000 rupees. It cannot be 50,000 rupees, and I cannot. Yeah, financial year. March. Okay. And the 165B says, save except the provision of the Act, the AGM special GBM can penalize a member for committing breaches in his responsibilities. Such penalty should be reasonable. There is one more line. This line is very important. It says, such penalty should be reasonable and equal to all such erring members. So, suppose Ameet Israni is staying in my society and I am the secretary of that society. He is my friend. So, if he does any breaches, I am not going to penalize him, or I'll penalize him just 100 rupees, and for the other member, I'll penalize 5,000 rupees. So, it should be equal to all the members. The penalty committee shall recover such penalties with proper care. Now, there is one comment here. As per the bylaw number 165A, the general body meeting is empowered to prescribe the penalties for different breaches of the bylaws of the society. As per bylaw number 165B, there cannot be different amount of penalties for similar type of breaches of the bylaws. So the bylaws wants to that everyone should be treated equally. I should not give favor to my friend Asrani because he's my friend. So for him, there is 100 rupees, and for the other friend who is always questioning me in the AGM and I have some grudge against him, so for him it is 5,000 or 25,000. It cannot be. It has to be at par. Now I come to the most controversial bylaw and grossly misused by the managing committee members against whom they have grudge against the members. Now 169 bylaws, if you see the heading, it is letting out the common areas. The heading is letting out the common areas. The society shall not let out or give on leave license basis or permit any subletting giving on leave license basis any open space available under the staircase, terrace, open ground, laws, clubhouse, common hall, etc. to any person, whether the member of the society or not, for any purpose whatsoever. So here what it says, that the heading is letting out common areas. The penalties for encroachment and common spaces. All open common spaces made for use of all members, example staircase, steps, landing areas, parking areas, lift, corridor, and such other spaces cannot be occupied by any member for his own use. The use of such areas shall be restricted to the cause for which they are made. Any member found to be violating the above condition by encroachment shall have to vacate the encroachment, and further else has to pay an amount equal to 5 times the monthly maintenance charges as per the month of the period for which he/she has encroached such spaces, and further members must not carry out any structural changes over and above the sanctioned plan without the prior permission of the society and concerned municipal authorities or competent authorities. So it is talking about the fabric, the character of this bylaws is, it is letting out common spaces, encroachment of on permanent basis of the common areas. Suppose if I am taking a shoe when I am cleaning my house, or as per Vastu, I am not supposed to bring the shoes in my house. So nowadays, people follow the Feng Shui and Vastu Shastra, where they say you keep your shoes out of your flat or out of your home. So I keep a temporary rack. I keep the shoes there, and then, or when I'm cleaning the house, I'm keeping the shoes in my passage in front of my door. And then after the cleaning is over, I take the shoe rack into my house. So the society is going to penalize me for 5 times, and that also from the retrospective effect. That is one catch. And secondly, now I purchased a flat where the bidder, initially the bidder was getting this balcony, then flower bed free of FSI, and it was given with the understanding that when he will give the possession and obtain an OC, most of the buildings are without OC, then he will encroach and put the windows outside, and everything is calculated in that price, and it is all part of the hall or the bedroom. Now if one of the smart managing committee member comes and he has grudges against me, So he will say now you have encroached from the original building plan. So from I have purchased the flat 5 years back, but the building is 35 years old, right? So from 30 years from retrospective effect is going to charge me the penalty. So now what I have learned, because we have written many letters to the commissioner, cooperative minister also. So in 2024, they are going to come out with a new bylaws. So they are going to change these bylaws because this is grossly misused by the managing committee members against the members. Now we'll go further. Also, member must not use flat unit for which it was meant or sanctioned.
Change of user.
Change of user. Any member violating the above directives shall have to pay an amount equal to 5 times the monthly maintenance charges as per month with reciprocal effect for the period for which such violation is existed. Now, this is going to create a very big disharmony among the members because he will have to prove that I have purchased the flat 1 year back, 5 year back. How you can charge me from the beginning? Because the bylaws is framed in such a way, so there is a gray area, and these matters are going to go to the High Court, and there will be some clarification from the High Court that what is bylaws number 169, where it can be applied and how it can be applied. Because till then, till today, nobody has approached the High Court. So this is going to be challenged very soon in the High Court. Now I will read the comments. Bylaw number 169 provides that society shall not let out or give or leave on leave and license basis any open space available under the staircase, terrace, open ground, lawn, clubhouse, etc. to any person. A society is prohibited to give any part of the property on leave and license on rental basis even to the member of the society. So the main characteristic, the main fiber, the main essence of the bylaw is to give it on leave and license, that is the common area. It is also provided that all open area or common area meant for the use of all the members cannot be occupied by any member for his own use. Yeah, all any members, yes. In violation of the said clause, the penalty equivalent to 5 times of the monthly maintenance be levied on concerned member with retrospective effect if the space is occupied since long period, even before the introduction of this clause, even before the introduction of this bylaw. Now, this bylaw is introduced in 2014, but the society will say that since 1990, this place was encroached, or you were keeping the shoe rack since 1990. So the clarity is missing, and definitely this bylaws is going to be challenged. And anyways, the new bylaws are going to come in the 2024, and we have written many things about these bylaws because this is grossly misused by the committee members against the members from whom they have a grudge or they keep on asking questions in the general body meeting. Yes.
The issue which comes up here, we are taking a little more time on this because it's a controversial issue. So out of the total time allocated, we have given more time to this. But a detailed reading of the bylaw is important. The first bylaw which we talked of, 165, talked about notice, talks about show cause, talks about general body, talks about agenda, talks about the charges to be made with probable care. Now, if those conditions are there in 165, those will be overriding condition even in 169. So when we come to 169, the same fundamentals which are given in the 165 would also be applicable. So anything that is being done has to be with reasonable care. The second issue which we talked about earlier, you be penalized for something which was not an offense when you did it. So that is the question which Bhimani Sahab has said, may have to go to High Court. Third thing is key, what is not in the law cannot be brought in the bylaw, because the bylaw is the derivative from the law and from the rules. Now, a detailed reading of the law and a detailed reading of the rules, I could not see any pointer which could lead the society to bring in a bylaw which is outside the purview of the law, which is outside the purview of the act, and outside the purview of the. If this is allowed to happen, bylaw being recommendatory in nature and not mandatory, whoever is approving the bylaw should delete this portion then approve the bylaw. It's a choice of the society. If it is not done, then managing committee meeting, which is too authoritative, can even bring a bylaw that if you put a rose plant in the garden, it belongs to society, and you put a plant, it will be a violation and start charging you encroachment on the compound. But encroachment is a word which is very, very difficult to define in these circumstances. And another word which is very important is any member found to be violating the above. So any member found to be violating. So it's a running present tense, which automatically means that if it was done before, he could not be found because it was done prior to the finding. Now, how the lawyers will argue this matter, is what maybe he doesn't want to give out his trade secrets, but think about that aspect also because it is to be found to be. So you should be caught in the act of doing it. And if it is something which was done previously and you were not there, because in the BMC also, when they give you a stop motion, they say that when you can only stop something which is in progress. And if something is not in progress, what are you going to stop? What has happened has happened. So these are a few of the things which those who are affected may want to look at. But very, very important is if it is a fixed point, there is a violation. If it is a movable, like shoes or racks or a small cupboard which is kept there for convenience, which is movable, then whether it would be encroachment or not is a definition which general body has to decide. For that, a show cause has to be issued. It has to be discussed, minuted. Then the general body will direct that the committee shall enforce the penalty. The committee on its own can never put a penalty clause in the bill without sanction of the general body because nowhere in the bylaw the managing committee has been empowered to raise a bill on the bylaw. So it has to pass the route of the managing committee. And then the managing committee going to general body can be sanctioned, can be challenged in the cooperative court, whether it is reasonable or not, because the word is reasonable care. So those arguments would also have to be taken care of. I hope people, everybody has got sufficient clarification. And if you have some points, please put it in the chat. At the end of the day, I could give more light on this issue because too many problems are being created and the orders are coming out mechanically and in a very robotic fashion without application of mind, either by the committee or in certain cases even by the registrar who blindly follows the wording but not the essence behind the wording. The other item that we have got as a duty for the member is to pay the maintenance in a timely manner. So one of the duties and responsibility and obligation of all the members to pay their maintenance timely. Even if you have a reason or you have a complaint, please do not stop the maintenance. Stopping the maintenance is an offense. Committing an offense against another offense is not the best solution. So pay your maintenance under protest. If there is a penalty, you can refuse to pay. Right there saying that I'm paying these following items and should not be adjusted against the penalty, should not be adjusted against the interest. If you do not specify what payment has been made and under what heading, society will have the right to adjust their payment against any heading in the bill. So if somebody has got a situation where you are paying part of the bill, then be very, very specific and tell the society that this shall only be adjusted against the certain heading, which are as follows 1, 2, 3, 4, 5, and no other heading. Kindly confirm. Which means that if society doesn't want to do that, they should return your payment with a covering letter saying, sorry, we will not accept your payment. Then the responsibility of charging interest and other things come into play. Then we have got the members' duties and responsibilities to support and volunteer in the cooperative movement. Sometimes, and most of the times rather, the members are expecting the 7 or 10 or 11 members of the managing committee to sit down and do things. That is not the purpose. The purpose is that every member has to take certain functions, volunteer, because cooperative movement is a volunteering movement. It is not a five-star hotel where 500 people will live in their flats and expect 11 people to be at their toes and answer questions. That is not the purpose. It's a collective movement, collectively to be done. And the committee can call upon any person who has a complaint to come and join the managing committee in a subcommittee and resolve the problem. That is the best solution. That if there are a group of people having certain problems, make a subcommittee, put them in charge of the subcommittee and say, look, these are the problems you are facing. We don't know the answer. We are ignorant. Now you come and help us out and find a solution. Then when the solution is got, then put the solution in the general body for everybody to say yes. Then take the next action forward. If we don't do that and go into litigation, we find that in the balance sheets of many societies, the legal fees figures are coming very, very high. If you go to the Joint Registrar Office, on any day, you find numbers of people there who are coming in for appeal or for revision. Why is that happening? It should not happen because the laws are so simple. These things are happening basically because either the orders are passed without application of mind in a mechanical manner or for reasons other than law. So those things have to be identified, and everybody, which includes the member, managing committee, registrar's office, the ministry, have to look into it to have a peaceful environment in the country, because the environment which is difficult in a society will go out of the society into working place, will go out of society into clubhouses, and then we will start having situations of disconcert, and we'll start having situations where there is more quarrel and fight for issues which are very, very small. And we don't have the time for those kinds of things. They should be avoided. It's very, very important that we don't create fights. And no orders should be issued either by the managing committee or by any member, or even I would request the registering authority or the supervising authority to do things in a manner that reconciliation is done. The matter is resolved to the best of the ability, because you can never have a 100% solution. Then get on with it. The next thing that is there is the activities in the society. In the object clause, certain activities are permitted, which is the activities pertaining to cooperation. Those are areas where the society has to concentrate, not on quarrels. We then have the people in the society who have different skills. We have somebody who's a good painter, we have somebody who's a dancer, we have somebody who has social skills, somebody who has soft skills. The managing committee should try and encourage people with soft skills to have occasions and cultural programs so that you have more unity, where also these problems can be resolved. Because if two people sit down over a common hobby, the differences disappear, and then they're ready to blend and they're ready to accept. But if you keep a wall and do not have any cultural activities, then everybody comes out to talk about my issue, my problem. It should be our problem, our issues. Till we don't do that, the entire cooperation movement is having a issue. We also have a duty cast on the members to take training. We are paying 10 rupees a month as contribution to do training, and there are institutions which are recognized. It is the duty of the committee to first send their own people for training, then the managing committee member, then all the members, 20% have to go every year. And by 5 years' time, each and every member should become knowledgeable. And once knowledge is power, so if you have the knowledge, there'll be less of a fight, there's less of a dictation from one person or two people in the managing committee who may be claiming to be more knowledgeable than the others. And then the others feel that you may have the knowledge but doesn't work in our society. Find a solution. So that is the area which we kept. Then there are other duties which are put in the bylaw, like you can't keep explosives, you can't do this, you can't. So those have to be followed. They are in the bylaw, so there is no question of discussion. Then we have got share capital, which has come up. Previously, we used to have 250 rupees, which was share capital. Now it has become 500. So for that, society has to issue a notice to raise the share capital, give enough time to the people to pay. There is a bylaw which says that the society will give sufficient time to the members to pay up the extra share capital, so that we come up with a requirement of 500. And society has to issue due notice of the demand and give members a reasonable period to comply. And now we have one more issue which is bothering, is corporate membership. We keep on seeing in the newspapers, this company has bought this flat, this corporate has bought this flat. But there is an issue in corporates buying flats, because there are some GRs which have been issued, and which either the managing committee or the corporates who are buying may have escaped their notice. So I'm purposely making this known because there are 2-3 cases which have come up where the membership cancellation has been applied for. The corporate has bought a flat. There are 2 or 3 essentials which are requirement of a corporate before they buy a flat. And there are separate forms which are to be done, filled by corporates. They don't have to fill the form of individuals. So most of the corporates may have filled the individual forms. So that has to be checked and corrected. And in the corporate form, it is very clear that the memorandum of association and the article of association of a body corporate should have a clause permitting the body corporate to buy a movable property in a cooperative society and become a member of the cooperative society. There are two conditions: to buy and to become. Then उसके बाद में एक और है, उसमें one more clause is there that it is for the use of the directors or staff of the corporate, which means it can't be rented out. It is not for profit making. So corporates cannot buy a flat if it is empty, rent out to somebody else. They can give it to their staff or their sister company or subsidiary company, which can be permitted or may be permitted. Once you apply to the society, they will tell you what to do. But this issue is very, very important because in case it is rented out, then you are violating the terms and conditions as a corporate. So these are issues which societies also check and encourage their corporate members to get their bylaws or get their memo, their articles amended accordingly to incorporate to become a member of the society. Then we have got rules. We have got something like parking rules. These are rules which are in the bylaw. Now, when we talk of other things like encroachment, those are not rules. They are not in the bylaw. So if we are going to decide and make a rule of how we are going to do penalty, then it has to go before the registrar. We have to amend the act or the bylaw to bring in rules for encroachment. Ki rules kya hai, what is called encroachment. Then make sure that all these things are followed before it is blindly implemented by the committee. Then there are also bylaws which say members cannot cut the trees and things like that. So if you read the bylaw, there are quite a few rules which are already existing in the bylaw. And I will leave it at that because the list will go on and on. But I think the viewers and friends who are watching have got a general idea that reading the bylaws is very, very important. And everybody must read. Bylaw copy is available either from the Federation office you can buy, or every society should have a bylaw which they can go and refer to. Now I'll come to the second part, which is the essential part, which is the compliance by the committee. Now, in compliance by the committee has got multiple facets. And here I would like to request Advocate Bhimani to come in, because there are issues in the rules which are, in my opinion, so I'm not giving a legal opinion, does not fit in with logic if it is not implemented the correct way. I will give some examples. There are some actions which the registrar is supposed to take on receipt of an application, a certain subsection. There are some sections which say on receipt of a requisition from 20%, section 83, for example, 89 on an application, or suo motu, or if the registrar so finds. Now, these are issues where registrar can call for an inquiry, hold an inquiry, and then, based on all the preconditions for that section, pass an order. Now, when we come to section 75 and we come to section 79, these are the responsibilities of the registrar. They are not the responsibilities of the committee. They are not the responsibilities of the member. Now, why I say that, I will explain. Section 75 says 75 1, 2, 2A, 3, and 4 that the committee has to carry out certain actions. So that part becomes the responsibility of the committee. 75 says, in the event that these are not done, then registrar has to take certain action. And the exact word that is used in 75.5 is, in the event of, I'll just read it out to be very specific. If default is made, that means in the event of a default. So if default is made, so it doesn't say there should be a complaint. It doesn't say registrar has to have a hearing. It just says if default is made. Now, when it is saying that default is made, how does the registrar decide that there is a default? Does somebody have to go and point out to the registrar that there is a default? Or registrar on his own has to have a mechanism whereby he has to discover through his own routine function that a default has happened. Now I will point out section 79. 1779 says society has to file certain returns within 6 months of the general body. In the 6 months return, all the items of 75 are included. So general body meeting हुआ कि नहीं हुआ, वो report है कि नहीं है, and it comes under a form called Y form, which comes with 79. And this has to be filed within 30 days. And registrar is supposed to maintain a register of all the societies under him and mark out under scrutiny whether the returns have been received or not. Because 79.4 also talks about registrar's duty to scrutinize. So if the registrar has a function to scrutinize, then I will read that quote. The registrar or the authorized person on his behalf shall scrutinize the returns, the information so received, take further action. That means the onus of taking the action is on the registrar. And registrar has to ensure that he or the authorized person scrutinizes all the returns which are filed under section 79. And 79 says they have to file, 1A says every society shall file a return within 6 months of every financial year to the registrar or any person authorized by him. And in the registrar's office, there is also a person from the DSA, from the society auditor office. He is also part of every ward. So it's a duty of the registrar's person and the DSA's representative posted in every ward registrar's office to scrutinize. And then, as per 4, the return has to be scrutinized and registrar has to take further action if necessary, is the wording. Now, if necessary means if he finds that default has happened. That is the meaning of, so I have to connect this, if necessary, with section 75.5, which says if default has made. So if default has made in calling a general body, 79 will tell you if default is there or not. Then this action has to be taken by default by the registrar. So he has to maintain a register. At the end of the scrutiny, if he finds that all the 75.5 is not complied with, he has to issue a notice and take action which is prescribed in 75. But here what is happening is, if person does not go to complain, or the registrar will then call for a hearing. And I've also seen some orders which say the show cause is hereby withdrawn. Now the power to issue show cause is given under 75, but the power to withdraw is not there. Still, I'm finding orders being issued, reasons best known, that I'm hereby withdrawing. So if you are withdrawing, then why did you give it in the first place? Because the section says that show cause can only be issued if the registrar is satisfied. So if you are satisfied that there is a default and you issue a show cause, then how do we have a situation of withdrawing a show cause? So there is, as we mentioned earlier, there are a lot of contradictions that are taking place. One has to really sit down and read word by word. And when you read the two, 79 and 75.5, the onus of issuing notice is on the registrar. Automatically, just a similar way, when we have a PAN card registered with the income tax office, we don't file a return or we don't file our annual document, nobody goes to complain to the income tax office. Automatically a notice comes. So it is an auto-generated procedural procedure. It is not a judicial decision. So 75.5 is a procedural item, and the thing should go as per procedure. So once the procedure is followed and something is happening, automatically a letter should come out from the registrar's office saying that we noticed there is a default. And even further on, the show cause is only to ascertain whether there was a reasonable cause, not whether the default has happened. So if I read 75, it says hereby the registrar shall give reasonable opportunity to the officer for explaining the reasonable cause why it was not done. That means the decision that it has not been done has already been taken. Then the opportunity is given for the society committee member to come and explain, oh, my father passed away, my mother passed away, or there was a COVID, or there was a heavy storm for the whole month, we could not do it, or the building collapsed. And then reasonable registrar will say, yes, there's a reasonable cause, therefore I will punish you with zero debarring, because it is 0 to 5. He can punish him with a 0 or 1 day debarring. If it is very mild, or 0, or it may be maximum if it is the cause is not reasonable. So the orders don't come out with the reason. So this is where all the managing committee members and the other members have to apply their mind when you make an application or when you write "Kaisa hua, vaisa hua." And the registrar's office also, I'm sure, after they see or hear this video, may want to read the section again, come up with a clarification as to a procedure to be followed by members to point out. And if they feel yes, it should be done, then they can issue a direction saying that if default is made, then please bring it to our notice, and then people can bring it to them. So that is the way which we can reduce litigation, because the whole purpose is to reduce litigation, reduce the pain between the members and the managing committee, create a cooperative spirit so that we are there. And if members know or they find that a default is being committed, they should come forward to the committee and tell them, sir, you have not issued the notice in correct format. Your agenda is not correct. Please recorrect it. Don't wait for the general body to happen. Then go and complain that default has happened. That doesn't make sense. As a member, it is your society, it's our society. We have to make sure that we go hand in hand. If there's a mistake by the committee, fine, we are all human beings. If you know better, then become a part of the committee and tell the society, look, this is the law, point out to them, and I'm sure they will correct it. Nobody wants to be debarred, nobody wants to go away. So those kind of cooperative spirit is where aiming at pointing out that we have to do things in a manner which is appreciable, and we live a happy life in the cooperative. Because we don't go and buy a flat with the intention, oh, I will buy a flat in the society so that I will go and fight with the registrar. Or I want to show my superiority in knowledge, and now I will go and impose my knowledge on the committee and point out faults. So fault finding is something which we can all avoid so that we correct it and get on with living our life. Now the other compliances which a society has to do, apart from the annual returns which I have pointed out under section 79, the audit and the auditors. Now the entire law, when you read, it goes in a particular manner. The manner is that after the audit accounts are prepared, it has to be left open for inspection of the members. Members have to point out to the auditors which are the faults that they find or discrepancies that they find. First, the society will be told. Society says, no, I don't agree. Member can write to the auditor, because auditor is being paid a fee of 100 rupees per member. Now, the reason for per member is that there is an artificial virtual contract established between the member and the auditor. Paying 100 rupees, society is collecting and disbursing to you. So I have a contract with you. Because in the Act, Section 81, there are two clauses which sometimes get missed out. One is that in case of an overdue, the overdue has to be examined by the auditor, which gets missed out. So in such a situation, when the list of overdue is given, auditor has to call for the member, call for the statement. Ask the member, tell me why is this overdue? Then he will say there's the wrong penalty which I have not paid. These are my letters I have given. Based on all the information, the auditor then has to issue a report. The section 81 says overview and investigation. So he has to go and then make a report. Now, if the society does not cooperate, committee says, no, it is my business between me and my auditor have no role to play, then safeguard is given in the same section which says auditor has to make a report on the working of the managing. The auditor can easily write and say, I wanted to do this. I was not given opportunity by the committee to speak to the member, and therefore I am qualifying my report. So this qualification will start appearing now, because all the auditors realize that things are to be put in a proper manner. They also have a role to play, a cooperative and guiding role. They have to act as a guide and holding with the committee and holding with the members in the cooperative spirit. So that is the area which is very, very important. And the items which are written by the members and which the committee does not agree, but the auditor feels is important, that becomes the O report. So that is what is then reported by the auditor in the O report, which is something like this. I'll try and show it to you. There's a book like this called the O report, and then there is the O form. I don't know if you can see it because the camera probably cannot zoom or can zoom. So ऐसा एक O report है. I think now I can show it to you. And then together with the O report, which is a register which has to be maintained by the society, there is the O form which has to be filled. O form is something like this, which has to be filled. The committee sent to the auditor for his signature by telling them what action I have taken. For the previous year, it has to go to this year's auditor. He will then investigate and check everything and file his report with the registrar. So this O report under section 82 has to be submitted by the auditor to the registrar. Registrar will then tell the society or the members that these jobs have to be done and kindly clear up these outstanding. Till such time that all the objections are not cleared, it will keep on appearing in every subsequent report. That is very, very vital. So that angle takes care of all the questions and the disputes which are there in the book Kagas Kirke. Which are there and which need to be taken care of. Now we have got the other compliances by society, which are also very important. These are in repairs. When it comes to repairs, we find that society has to visit. The bylaw directs the committee member, secretary, together with one committee member, to visit the flat, because the building is the property of the society. The flat is the ownership of the member. It is the duty of the society to ensure that the building is managed in a proper manner, which is there in the object clause. So if you read the object clause of the bylaw, it says to manage and maintain the building. So under that provision, the committee member or secretary has the right to enter the flat, inspect the damage, get the damage repaired, give the bill to the member and charge him and recover it through the maintenance by following a certain procedure which is laid down in the bylaw. Then we have got questions like I'm giving an application, committee is not accepting it. Now these are all offences which committee should try and avoid, because if you don't know the problems, and this is addressed to the committee members, if you don't know the problems, how are you going to have a peaceful life? So you should know the problems. If the problems are wrong, address it. If the problems are doable, cure it. If you find there is harassment, write to the registrar that we are being harassed, please file a direction to the member. The registrar has the power to pass direction not only to the committee, but also to the member that please comply with these, comply with those items. For example, if it doesn't open the door to allow you to enter, the registrar can give an authority to the society to take a police and open the door. The section 80, usko power hai. So then it has to be used. You get the order, give him a notice, but procedure has to be followed. And general body should always be supporting that to the committee, because committee does not have ab initio a policy power. Then we have got the bylaws, the documents and application under bylaw 63, where it is given and the procedure prescribed that within so much time it has to be placed. If an application is given and there is a general body meeting coming up, then that application has to be placed before the general body, even though it is addressed to the committee, because that is what 63 says, that any application received should be placed before the managing committee or general body, whichever is earlier. So if you give an application one day before, even if it is a special general body, even if it is not in the agenda, it has to be placed before that. That has to be taken care of because it's part of the bylaw, and then the agenda of the special general body has to start. This is very, very important, so that the problems are sorted out. The intention is problems should not become cancerous. Then we have got the issue of redevelopment, which is a major issue and which I have spoken of earlier. And even in the redevelopment, there is something called section 79, which has got punishment, which Advocate Bhimani mentioned at the beginning of the discussion. And there it is very, very important that every aspect of the notification, which is mandatory as per the act, because if you don't follow, the committee will be removed. So that is an aspect which needs to be heard. There may be judgments which are there, will not go into judgment, but then if the society feels that they don't want to follow and the registrar passes an order as per the bylaw, the registrar has to pass an order as per the act, rules and the bylaw. Then there is a conflict. Again, I think it may have to go to High Court for that, whichever way it is. Yeah. Or the commissioner may be giving out clarification or guidance on how it has to be. And in that development, all the points which are there to be discussed, 100% transparency has to be given. You can't have a 51% transparency. Because I have seen where managing committee trying to push through a development agreement, only about 50-51% turn up. And this is unanimously passed by 51. 51 can't de-house because redevelopment is basically a process where people are de-housed. You are being removed from your house with no guarantee, no warranty, either by the managing committee or by the developer or by anybody or by the registrar. And the problem has to be solved by the member who is now without a house. So caution has to be taken by every member before they vote blindly that this is okay or this is not okay. And the redevelopment agreement has to be read clause by clause, which means the meeting of redevelopment should take 3 days, not 40 minutes, because every clause have to be read. Members have to be given a copy of the redevelopment AAA agreement so that they can consult their lawyers, consult their well-wishers, and come out with any problems that are there. Because I've seen quite a few redevelopment which are having issues which can be interpreted in multiple ways. Then when everybody is removed from the flat, nobody is there and the building and the property is in the custody of the builder, he will obviously interpret it in the best way that suits his profitability and not the interest of the members. That caution people must take before they go to vote. And my request to people who are going in 79, please ask the managing committee and the registrar's representative, because in under 79A, registrar's representative has to be present. It is the duty of the registrar's representative to read out the section, and on every matter, the clause in the notification, he has to ensure that all the members have understood and they accept it, which by itself means that the representative of the registrar should also be trained to understand what 79A is. Right now, what I am noticing is that the registrar representative is there. He sits down. The chairman takes over the meeting. How many in favor? How many against? Put your hands up. Look at the video and say, I agree. And everybody says, I agree. And the registrar's representative files a report. I was present. Meeting lasted 20 minutes. So many so looked at the video and said, I agree. That is not what 79 is for. His report should say, item number 1 in 79A was read out, was discussed, and the chairman and the expert who was there explained to the members the upside and the downside of that clause. And members, after knowing the upside and the downside, then agreed to accept that clause. That resolution has to be passed, is not there. This leads to a lot of problems later on. So all those people who are going in for redevelopment, please insist that clause by clause reading of the 79A notification is done and write to the registrar when they make an application. Because the society committee makes an application that we want to hold a meeting. Immediately the notice is issued, members should get together and write to the registrar. Yes, meeting is happening, but we want the meeting to be conducted in a transparent manner. Because you can't have 51% transparency. Transparency has to be 100%. Number 2, if it's 100% transparency, there would be no dispute. So if there is a dispute, means there is a problem, which means that 79A has not been complied with. So please make sure all the members who are going to follow it, because once you are out of the flat, you don't have a recourse to come. So that is very, very clearly should be understood by everyone. Now we have got the other items, which is the revenue on hoarding. It is the duty of the committee on that particular bylaw and the notification which is issued again under 79A. This notification is also issued under 79A. The 25,000 rupees that we charge as premium maximum is also issued under 79A. There are many notifications which are under 79A and they are all binding. So 79A is also binding. Now it comes to the hoarding, the money that comes from the hoarding is not the property of the society. 50% of that after taxes has to be put in sinking fund, cannot be used for repairs and maintenance. And the remaining 50% has to be distributed as bonus by check, not to be adjusted amongst by outstanding. So it says to give a bonus. Bonus means you have to issue a bonus check, just like you get from your company or from your office. When you get a bonus, you get a check of it. Then we have got the issue of apportionment. When you have multiple headings, you make a payment. It is society's duty to ensure that the collection process is done within 2 years. Because we have situations where a person has passed away and the society doesn't change the name, doesn't bring in the new member. It is the duty of the society to ensure that the name of a dead person is removed from its records, because you can't have a contract with a dead person. There can be no contract. So if you raise a bill in the name of a dead person, can you recover it is the question. The Act is very clear. Section 25 says that on the death of a member, on the death of a person, he ceases to be a member. And 25A says that after that, the society has to remove his name from I register and J register. And then if they don't do it, society or the registrar will send his representative to remove it from the register. But we still find in the outstanding the name of the dead person, and the new person is not brought in as a member. So the process is very systematic. Person dies, he is removed. The new person in his place has to be brought in immediately, because in the bylaw it says payment has to be made by issue of a bill. So if I am a new member and you don't issue a bill in my name, can you collect the maintenance from my name? That is the question that arises. So these things should not come in. Even the 154B13 has been made so simple that on death, if somebody has a testimonial document, make him a member and owner. If you don't have that and you have a nomination, make him a member, the nominee, and he becomes a provisional member. Nominee is entitled to become a member. Nominee doesn't remain a nominee after becoming a member. He is a nominee prior to death. On the death, he becomes a member because he is nominated. Society has only to admit him. If you read the thing, society shall admit. So that is not making you a member. You are already a member by virtue of nomination. So you become a member. And part 3 of that section says that if there is no document and there is no nomination, then anyone who appears to be shall be admitted as a member. Appears to be what? Appears to be a legal heir or a legal representative. That means the list of outstanding, the name of the legal representative in bracket or legal heir should be there. So he is a member and he has all the rights of a member. He can vote, he can stand for correction, he can stand for elections, he can participate in the committee meetings, everything he can do. So by calling them a nominee after death is a misnomer and it is wrong. So committee has to make sure that those things are correct and they go as per the Act. That is a responsibility for compliance. So when compliance is done, it should be shown that society committee has not complied by bringing in the person as a member. Then we have got the issues of notice board. Now there are so many orders coming from the registrar or so many notifications. Bylaw 164 says that you need to have a notice board. If there are 2 buildings, 2 notice boards. And all such correspondence documents should be put on the notice board and displayed. Now, we find that many a times these things are not being done. So these are non-compliance by the committee and there's a punishment at the end of the day for non-compliance. Then we have got a very beautiful bylaw in the same 2014, which is assistance to widow. If the member passes away, the committee has to assist the widow. The wordings are so beautiful that the committee on death of a member within a specified time limit has to assist the widow so she doesn't get embroiled in legal issues. So usko member bana do, then she can go and get her succession, she can go and get whatever. But she should be made a member and all assistance has to be given. That is the wording in the bylaw. But what happens in reality is many committee members say, no, we don't know you. You have not filled the form. But you have to assist them in filling the form. Sit down with the widow. They're part of your family. Don't treat the widow as an outsider. But those things are something which are not compliant, which need to be compliant. Then we have got the issue of legal fees. This is again a major issue that is arising in many societies where you write a complaint, the lawyer is appointed by the committee, the lawyer goes against you, the right gives you a notice, then the legal fees are charged and it is put in your bill. This is a settled position. There are judgments and judgments and judgments that all expenses are to be appropriated equally among all members. It cannot be charged to one person. But still it is happening. So members should be aware of that. Committee members should all be aware that they are not complying if they charge it to the committee. And second thing that we must understand that the lawyer is appointed by the society for the benefit of all the members. So if the lawyer finds that the committee is doing something wrong, it is the duty of the lawyer to inform the committee, sorry, I will not issue the notice to the member because your notice is wrong. He cannot just say I'm appointed by society. Doesn't appoint. You can't appoint a lawyer against yourself. And if the managing committee wants to appoint a lawyer, then they should pay the fees on their own. If a society appoints and the cost of that is apportioned to all the members, then everybody has contributed equally to the fee. The job and the duty of the legal advisor or legal guide is to study the solution and tell the committee, look, this is the way the law is, and please do this. Then there will be no dispute. But we find, I've seen so many cases where a legal notice is to be sent to the member on something which is his right, and then he has to go to court, establish his right, it gets rejected, then go to joint registrar, establish his right, then again it gets rejected for whatever reason, then he goes to High Court and High Court then says, no, this is not correct, and what the member wants is correct as per law, and comes back again. So you have the legal fee in the registrar's office, you have the legal fee in the court, and these are all charged to members. So these are issues also which committee members have a responsibility to ensure that they don't go into futile litigation. And one more important thing, which is in terms of liability on collection, there is something called law of limitation. And if a member dies, the new member does not come in or does come in and society does not collect or does not move to collect, then they can never collect because section 33(1) says that after 2 years, the society cannot collect any dues from a dead member. And that will be applicable from the date of his death or from the date of cessation of a member. That means even if a member sells his flat and there is an outstanding, and society does not go to collect, then from the date of cessation of membership, after 2 years, society can never collect the money. Third important thing in this is that it is the duty of the society under the new law that who is a defaulter that has been defined. Dues have been defined. So, the moment a defaulter position is created, that means after giving notice and that time, society has to immediately move registrar under 154(b)(29). If the society does not move to collect and they leave it there collecting 21% interest, then it is going against the spirit of cooperation. The purpose is not money making. The purpose is not to collect outstanding and interest and allow the interest to accumulate. If society does not take within the time, then if the order comes against, the committee member would have to make good those losses because they feel the loss has happened. And the registrar then passes an order and rejects 29 that it is not as per this. Then who then pays the shortfall which approved in the accounts, approved in the general body? So every committee member should make sure that in March 2024, if there are any dues of 23, please move the registrar prior. It is your duty to move it. Then get your order. You can't leave it there and collect them. When you take interest, you are putting the interest as an income. Then you are putting the interest part carrying over in your reserve. You are carrying over the interest in your repair fund. So you are creating a fictitious account. Account is not reflecting a true and fair view. The auditors also have to make sure that they point it out and say that the accounts are not reflecting a true and fair view by these actions and these entries which have come. So these are all issues which the committee have to decide. Committee has to cooperate with the auditor has to cooperate with the members. So it's hand holding all through. And then you will have a happy and a peaceful society. So I think I've covered quite a bit of.
Yeah, we have covered everything.
Not everything. I still have 1 hour of talking to do.
So the compliance by the members, compliance by the managing committee, and compliance and responsibility of the deputy registrar, which normally doesn't happen.
Not. It
Now we have many questions. Sunil Landane, can any member keep their shoe rack in the lobby on the floor?
It's a movable thing. You put it inside. That's all. If it is a vastu and everybody wants to do it, after all, societies of cooperation. And if everybody feels that yes, they can put their shoe out, and it is a tradition.
If you fight for small petty things like this, then somebody will say, why you have kept the letterbox outside? Right?
Why the nameplate is outside?
Why the nameplate is outside? So, but you should see that when you are keeping a shoe rack, which should be of a temporary nature, not you construct there and block the passage, but you should also take care that when you are keeping that temporary shoe rack, which is of a temporary nature, does not obstruct if you want to run in the case of emergency if there is a fire. So it should not obstruct you as well as any members, and it should not cause any annoyance to the members. That you should take care, and then it is a cooperative society. And there is no hard and fast rule in the bylaws that you cannot keep the shoe rack, but it should not be of a permanent encroachment, and it should not obstruct the way in case of emergency. Otherwise, if the BMC comes for a round, they can fine you that this is going to obstruct in the case of emergency.
The fire brigade.
The fire brigade, yes. My question, if the member is billed for wrong charges and continue to bill with penalty and interest on part payment. See, he explained you in the beginning, CA Ameet Israni, that whenever you pay a bill, when you're paying a check, to specify that this check, this amount is for so and so purpose, kindly specified. And the remedy is to have a meeting with the committee member, give them everything in writing, what are your grievances, and if nothing has happened, then you have a remedy in the deputy registrar.
Here, one thing is important.
Yeah.
You can go to the registrar and inform them that the billing is being done not as per the bylaw. So wrong bills are issued and ask the society to correct them. That will be the angle that you will have.
So I hope Sunil Angane and Hari Murlidhar, your questions have been answered. Now we have one question from Arihant Logistics.
I want to interrupt you.
Yeah.
You want to talk?
Yes.
Operation.
Yeah.
Okay. Now there is a contract act which says that the person who pays the money, in case of multiple debts, multiple headings, then the payer decides which heading he wants to pay. And creditor does not, the receiver does not have a choice but to accept. If he doesn't want to accept, he has to return the money. The moment he accepts the funds, then he has to follow the direction given by the payer. So this comes under Contract Act. And in an invoice, we also have a contract between the member and the society. This is also covered in the audit manual by the department, where it specifically says that section 58, 59, 60 of the Contract Act is applicable.
Now there is Arihant Logistics. Honorable Commissioner of Corporation failed to publish panel of administrators since 1st April 2022. The administrators are working without proper authority of revised list of panel administrator. Now see, what I have find a way is, recently I was there in front of High Court, double bench. The judge was Honorable G.S. Kulkarni. Now my matter was pending in the RERA for last 1.5 years for the compliance of the order. My client had got the order, but the builder was not complying the order. So we filed an application for compliance of the order in the RERA. One hearing had happened in the last 1.5 years. After that, there was no hearing. We wrote several emails. We went there personally, gave them the hard copy of our application. That matter has to be expedited. Now, nothing happened. So what was the remedy for me was to file a writ petition in the High Court. In the first hearing only, within 3 minutes, the bench, honorable bench of G.S. Kulkarni, granted me my prayer that the RERA should dispose of this matter and give the ruling within 6 weeks from today, that is from 4th January. And from 4th January till 14th January, I should get the order. And meantime, 2 hearings have been taken place. Now it is kept for final orders. So whenever you find that such things are happening, catch hold of a good advocate who has little bit of activism inside him, tell him to file a petition in the High Court, and the things will smoothen up automatically. So the remedy is available in the High Court if the authority is not cooperating or it's not functioning. Now, Jagannath Rao Kotecha Lakota. Sir, thanks for explaining the controversial bylaws so beautifully. Thank you, Amit. Michael, during AGM or SGM, managing committee evades queries, yet coaxes mute general body to pass the resolution based on misleading information, knowing fully well such resolutions are repugnant to Act, bylaws, and rules. What is the remedy available?
The remedy is very simple. Members should ask for a compliance officer to come in and look at everything in the society and issue a compliance report, like you have an ISO report, or in the hospitals you have a compliance report. We have got a lot of people who are specialists in cooperative society matters. They can be engaged to spend some time in your society, attend 1 or 2 meetings, and guide people. But the intention to get compliance is important. If the committee doesn't want compliance, then they will not do it. If the members get together and tell the general body, look, we need compliance, and we should have a compliance report every 3 years. So once in 3 years, if you get yourself complied, then chances are that all these questions of orders not being followed, procedure not being followed, high-handedness, superiority would be reduced to a great extent, because the compliance officer will give a report which will be open to everybody, and a report will go to registrar and to the auditor. An auditor has to incorporate that report in the audit report, and then it will come in its old report, and in the old report, compliance has to be complied, and it will remain in the old report till the committee does not comply. And if after 3 years the report is not complied with, registrar will then issue a direction to the committee to comply, and if they don't do it, then remove the committee. That is the procedure.
Now, Aryan Logistics, Rule 61 not followed by most of the societies. Why Honorable Commissioner is not coming up with a clarification or circulars?
My answer is why you are not reading the bylaw and the act. Please read the act. It costs you only 1,000 rupees or 1,500 rupees to buy a book. Every society has a book. And if you don't have comfort in reading, when we come online every Saturday, please put your questions beforehand so that we can cover that subject, give you the guidance. And then bylaws, it's a small 80 rupee document. It's more like a user manual. Please read it. Once you read it, you will have the answers, because in the act, you have the questions and you have the answers.
I hope I am pronouncing the name right. Eugene Athaide. How can we deal with a secretary acting in autocratic manner, consults no one and takes one-man decision? No MC members object to him due to fear, and also does not respond to any member. See, you will have to design your own way. I'll give you some examples. Send him a letter. If he's not accepting a letter, send him a registered letter. You can always approach the deputy registrar. Yes. So you can do that. There are remedies available. Only thing is, you want Bhagat Singh, but you don't want yourself to be Bhagat Singh. But आपको Bhagat Singh चाहिए, लेकिन आपके पड़ोसी के घर में चाहिए, अपने घर में नहीं चाहिए. That's where the problem starts.
To intervene here, there is a provision in law, section 24, that every member should go for training. If you are not sent for training, write to the registrar, I am paying 10 rupees a month. I am not being sent for training. Committee will get an order. इस आदमी को भेजो training में. Then go and learn. The training is for 1 day or 2 days, and they teach you everything there. There's no cost to you. The society is going to
already paying means. Now they have come out with 3 hours.
Whatever it is, yeah. But you get the understanding.
Ashok Rajmani, even statutory auditor not confirmed report of government audit. the question is not clear, so you rephrase your question and send it to us. We'll see that we'll reply you. Aryan, who scrutinizes the audit rectification report submitted by the society to the registrar office?
I've covered that question under 79.4. The registrar, to an authorized officer who is the DSA, has to scrutinize.
So you watch the video again.
Proceed there.
Yeah, Aryan.
Or what you can do is ask for a scrutiny report. Write a letter to the registrar, put a 10 rupee stamp, audit RTI, and say, give me a copy of the scrutiny report. You will get it.
Sir, you mentioned section 7, subsection 2 shall scrutinize returns and honors on taking action with registrar. None of the registrar in Maharashtra takes any action suo moto. See, you will have to pursue how actually there is lack of infrastructure also in the deputy registrar office, even in the DGR office. 4 days back, I had a hearing in Malhotra House in DGR, and then he was called in the last minute to Mantralaya. So all 125 cases, both the parties, they appeared there, advocates appeared there, but a long notice board was there that your matter is kept on April so and so date. So these things are happening. So we'll have to pressurize the government, pressurize the commissioner that to get that advance notice on our email or on WhatsApp that the hearing is postponed on the next day. So we don't travel from Borivali and Andheri and from Kurla to Malhotra House to VT to attend, and then we come to know that the matter is adjourned. So we should go for virtual hearing like how it's happening in RERA. So it will save time. I can attend hearing anywhere where I am. So we are also working on that. You can also put some letter to the commissioner for that. That should be this thing. Om Prakash Iswalkar, can SGF take unanimously decision to recover legal charges incurred by society from a complainant member only instead of all members equally? Violation of bylaw 66 subsection K.
I have covered this already. It's a settled position that appropriation as per the bylaw has to be done. Even if he passes the order, there are plenty of orders which say that they cannot do it. And if it goes to joint, he himself has issued, the current joint registrar also issued such an order on so many cases. And he has asked the society to rebuild, put it in the. Now here one issue comes in, which is a trick played by some managing committee members when they want to go legal against a member and the other members in the general body say हम fee नहीं भरेगा. The committee or the secretary साहब आपको कोई प्रॉब्लम थोड़ी है, वो आदमी को लेसन सिखाना है तो उसको ही बिल भरना पड़ेगा, हम उसको डेबिट कर देंगे, आपको पैसा नहीं लगेगा. Based on that assurance, all the members put up their hands से अच्छा ठीक है, हमारा भाई मरता है तो मरने दो. So there is no brotherly in that situation. As long as money is not going from my pocket, you can sue my neighbor, not realizing that one day I will also get sued with that same attitude. So once he says that, there is no financial approval given. Now, if you look at the bylaw says that the committee does not have the power to spend money without specific approval. The only power they have is depending on the number of people to spend 50,000, 100,000 or whatever for repair only, not for any other heading. So they can't use that to pay legal bills. So the moment it is not paid, it is to be apportioned to everybody, then the members will go and tell the registrar, if this was never approved, the funds were used from society office, therefore it has to be recovered from the secretary or the chairman. Make that matter before the registrar, and I can assure you, you will get an order that this money should be recovered after due inquiry and process from the personal pocket of the committee member who has misled the general body. But you all have to go and understand and read the rules, read the laws. And even after you go through this video again, I would request you to repeat the video 5 times. Look at the meaning of what I'm saying, because when I'm speaking, there is always a hidden meaning which I may not be able to voice out. But when you hear everything, please come to the conclusion.
Jagdish Gaikwad, AGM for the year 2022-23 is not yet kept by the managing committee till date. So what should be done by a member of the society, or what can a deputy registrar do regarding this?
Again, read the act, all the answers are there. Read the bylaw, all the answers are there. And I would request that after the next meeting, when we have this one, I'm going to answer. But next meeting onwards, what is in the bylaw, I would not answer and take people's time. This is the duty of the member, which is what I say, compliance of the member, to read the bylaw. It's the duty of the member to read the sections of the act. And then if you don't understand, put the question in the group. Somebody will answer you. I will answer you. No problem. Please read. Come prepared. Now, in this question, I will tell you, if the meeting is not held, then there is a violation of section 75. So for this, you will have to file an application under 79, asking the registrar to give you a copy of the 79, where the returns are filed. In the return, the notice and agenda will not be there. And then you have to tell the registrar that as it is not there in the notice and agenda, then kindly do your duty and know that default has occurred. So take action under 75.5. That is the route you will have to. But put a 20 rupee stamp on your application. Don't send without a stamp.
Matthew, the builder says that 45 days vacation notice, and vacating the notice without PAAA, is it valid? And without approved plan, now builder is saying that the member can't talk to builder and to address to the issue to the society. See, that's why in my lectures on redevelopment, I say that you have to have a very good lawyer who is interesting in protecting, yes, protecting the interest of the citizens and the members of the society. So right from the day one, when you start a redevelopment, you appoint an architect and appoint a good legal advisor who is going to stand by the society expert and the cooperative society expert. So now what happens? I'm going to attend one more meeting in the 11th February, around 1500 members, Federation of the Society. So I have told that you distribute to all the members the tender copy and whatever our DA will be there to all the members, and let all the members come with their queries, because transparency is there in your dealing. There will be no problem. Otherwise, there are many cases. You just type Pearl Housing Society, Goregaon Pearl Housing Society, and you will see that 12 years they were roofless. For last 6 years, the builder was not paying them rent, and they had to terminate the agreement and construct the balance work which was left by the erstwhile builder, who is in jail now. So this thing should not happen. So many out of 12 members, without seeing the new flat, they went into the new world. So this should not happen. So PAAA, the development agreement, the power of attorney, and the declaration, whatever the consent, everything has to be go through a lawyer who will see that your interest is protected, and this thing should not happen. And even I'm requesting all the managing committee, when you are going for a redevelopment, please be transparent. Otherwise, you will face problem and your members will face problem. वो हिंदी में एक कहावत है ना, अपनी बोटी के लिए आप बकरा काट देते हो, वो चीज नहीं होना चाहिए. क्योंकि आज अगर कोई भी सोसाइटी है 50-60 मेंबर की है, अगर फेडरेशन है 1500 मेंबर, अगर एक गलत डिसीजन होता है तो 1500 फैमिली, सो मेनी पीपल्स, एक घर में 6 आदमी तो हो गए, तो वो लोग का सबका क्या होगा? You have to keep this in mind and don't just go with the sweet words of the builders. You say firm that no, this is what we want and this has to be there in our agreement. ये जगह आपकी है, आप सोच लो कि वो अगर उसको खाली प्लॉट हो, अगर वो लेने जाएगा वो एरिया में, तो कितने करोड़ का होगा? उसको 1000 करोड़ रुपए का वो प्लॉट होगा, और वो सिर्फ 10-20 करोड़ रुपए आपको देके, आईडी देके आपको खाली करा देता है. तो सबसे पहली बात, जब तक आपके पास आईओडी नहीं आती है, nobody can vacate you. You can go to the court of law. Without IOD, nobody can vacate you and demolish the building. That is the rule number 1. That is the settled principle. Now, next question is
one more intervention.
Yeah.
To clarify that question. Get the tender copy. The tender copy has to be published. Once it is published, it is open to all the members. All the members have to make sure that they read the thing. Second thing is that every document, members have to insist that they are given enough time. Enough time is 15 to 30 days. All the members should carry the documents to their own personal legal advisor. Seek personal opinion. It is your house. And second thing which I need to request all the participants, please stop calling it redevelopment. This is not redevelopment, it is dehousing. We should start changing the wording and say we are going into a dehousing process. That means we are first going to throw people out of their house. Once you tell people that this meeting is here to throw you out of the house, then let us see how many people will say, yes, I want to be thrown out of the house. When you give a flower and say it is a redevelopment, flower is where there is no seed to the plant. It's show a flower. So people even get the flavor of the flower without them knowing what flower it is. And it's an imaginary thing on which they start feeling कि हमको 500 square foot मिलेगा, 2000 square foot मिलेगा. Those are all illusions. So I am also now addressing people. When they call me for redevelopment, I say no, we don't advise on redevelopment. We advise on dehousing people. That how you will be dehoused by the con people who are part of your group and what problems you will have. First, I give them the downside, then I give them the upside. Today, what is happening is you are getting the upside and downside is not spoken about. So we have to open up our minds. In any meeting that is being held henceforth, please call it dehousing. Do not call it There is no redevelopment till you get your flat.
Now, one more question is, Platon rule, don't understand, which you stated of specifying the payment if payment still not adjusted under the said heading and payment encased offense will be under Contract Act or MCS Act or any specific. See, now what he wants to say is that as per the heading, if we give the check, right, the society encashes the check but does not put in that heading but adjust it somewhere else. So where the complaint should be there, in the MCS Act or in the Contract Act?
When you give a designation payment, the Contract Act is very clear that these things have to be done in a particular manner. Well, appropriation of funds, payment received on different headings. So the right is given to you. You'll have to move court. That is for sure, because it's a breakage of a contract. But if you talk to the auditors and show them the audit manual where it is clearly specified that this is the route to be followed, maybe the situation would be easier. But if you have a crooked managing committee, then I am dealing with situation where possibly the managing committee is acting out of ignorance or lack of knowledge. But if the intention of the committee is to do wrong things, then you will need a lawyer who will advise you how to correct the, whether you want to file a police complaint or whichever heading it may fall into, or how you want to do it, whether there's a criminal charge. Because to my mind, it will be a criminal act, which I think criminal lawyer may be also able to see if he can put it in. I don't vouch for that because that's not my forte.
Can residents perform puja and worship idols in the common garden area of the society?
We are today talking about compliances. We are not talking about practices. By law, the object permits us to do cultural activity. But in our system, a lot of cultural activities come out of festivals. So there is a confusion between festivals and there's a confusion between cultural activity. So a puja would be called festival and Garba dance probably would be called a cultural activity. So it's all upon the members how you want to do things, what you want to do. Or you may have a Ganpati puja, but the immersion is again taken as a cultural activity. Or you have a Dahi Handi is taken as a cultural activity. So our system is such, so one has to play it by the ear and make sure that you don't do certain things which upset anybody. And people go along holding hands, and there has to be a blending which is done because cooperation means blending. And bending, I've said that many times. You have to bend and you have to blend.
Praveen Iyer, is it one member, one vote, or one property, one vote?
One member.
It is one member, one vote. If I am having 10 flat also, but my vote will be considered only as one. So, especially when the conveyance has not happened at the time of handover of the society. See, there is a MOFA provision, and even in the RERA, the timeline is given once the occupation certificate is obtained, right? So within he has to make a society in that particular time frame, and within 6 months he has to hand over, transfer the land into the name of the society. Only and the bylaw number 5 of the cooperative society also says that the primary object of the committee is to get the land transferred in the name of the society. It is that simple. Yes. First object. Can society MC collect old builder dues on account of maintenance which were due to a member during the tenure when the builder was managing the building?
Yeah. When the society is formed, it is either formed by the builder or formed after the people have taken over and they go and form a society in non-cooperation of the, because by law builder is supposed to form a society. Now when the builder is forming a society, he issues 3 documents, Form X, Form Y, Form Z, to the chief promoter. The chief promoter says there that I have received all the money that people had paid prior to subsequent maintenance for the full account. It is there in the bank account. He has full details. Then 45 days are given to him to settle everything. And for 1 year after the society formation, there is a selected committee who has to put everything in place and then go for election. The problem happens when the person who is the chief promoter becomes the chief promoter by virtue of greed, because the builder promises the one extra car park. He signs on the blanket plan and does not do what he is supposed to do. So those are issues which are there, and members then have to get together and hold the chief promoter responsible and file criminal charges against the chief promoter for not doing and misleading the people. That is one. Two, if the people have connived together, then again it is the criminal offense of connivance or extortion or whatever you might want to call it, or your lawyer might advise you. They will be in best position to guide you. But in the cooperative law, the laws are made, but members do not read the law, do not follow the law, do not implement the law, do not complain at the time the law is broken. We complain when it becomes cancerious after 5 years or 7 years, when the chief promoter must have sold his flat and gone. So everybody has to be alert from day one, which is the motto of this forum. The first thing that we say when we start, it is to enlighten the members. You can repeat that first line for me.
Yeah. It is to make aware the citizen of India what are their fundamental rights, right? So we, the citizen forum is empowering citizens. We want to empower, but it is your own duty also to read the bylaws and understand it. And if you have any difficulty, you can WhatsApp to us. Now, Praveen Iyer has one more question. How can a company or a corporate body formed for a special purpose nominate people for attending the society meetings? Will they be authorized to be part of the managing committee or office bearer?
I have already covered that. I think maybe some members may have missed it out. Corporate body can buy a flat as a corporate. Individual can buy, partnership can buy, trust can buy. Anyone which is a registered body can invest in property. That is the law. Now, once you have bought a flat, the articles and memorandum of association of a company should have a clause in their memorandum and articles empowering the company to invest in immovable property and buy a flat in a cooperative society and become a member of the cooperative society. And further, give an undertaking that it is for the purpose of residency of a director or a staff of that company or a subsidiary company. That's the first part. Now, a body corporate cannot attend, so they have to send a representative. In the case of partnership, one partner has to appear. In the case of trustee, one trustee has to appear. In the case of company, a director or a person authorized by the board of director has to appear. So that person represents the company and is a member, can therefore vote, stand for elections, be part of the managing committee like any other member.
Okay, now one more question, last question we are taking. The managing committee members have not yet admitted few members since the last 2 years and not issued certificate to the new members. What action can be taken?
Is this a new society? or is it an old society who has not entered new people? The clarity is not there.
Not that.
If it is a new society, then within 45 days, you have to induct everybody. That is the wording. So if there is a builder who has not sold, the builder will also come in as a builder promoter. There is a provision for builder promoter in the new act. He will hold the shares, he will pay the tenants, he will pay, but then he will not be in the committee and he will not be voting because he's still holding flats in trust for a buyer. The buyer becomes a member, so he's only holding it in trust for a buyer who becomes subsequent.
Okay, now we come to the end of the session. There are many questions, and you can write to us. Our WhatsApp number is there. We'll revert it back to you. मैं उम्मीद करता हूं कि आप सभी को ये वीडियो सेशन पसंद आया होगा और आपकी जानकारी में कुछ वृद्धि होगी और जब आप इसे शेयर करेंगे तो हमें बहुत ज्यादा खुशी मिलेगी। आप लाइक कीजिए और अपने अपने कमेंट्स आप कर दीजिए, पोस्ट कर दीजिए। हम उसके कोशिश करेंगे आपको जवाब देने की।
Also suggest what subjects do you
Yeah,
like?
and if, whatever you want the next topic to be on the Saturday, kindly आप उसमें डाल के रखिए चैट के अंदर, तो नेक्स्ट टॉपिक हम वो सब्जेक्ट पे और वो टॉपिक पे हम लोग कवर करेंगे। So stay connected. You again in the next video. Till then, stay healthy, remain safe, and Satyame Vajayate.